Okay, here we are. Hopefully sans cat noise. With this issue. This act allows corporations to claim to be the authors of a character or work as long as it was done so for hire. So the act allowed corporations to claim to be authors. Right. So it preserves this concept of work done for hire. They have to own the intellectual property because otherwise, how are they going to exist as institutions? After this law was put into effect, many publishers, including Marvel Comics, quickly made all their artists sign waivers saying that they had done the work for hire. Okay, I see. Yeah, there's a lot about this I don't understand about, like, well, there might be some cat noise still. This is why artists and authors like Jack Kirby never saw ownership of their own creations, even after measures like this one that intended to help creatives came out. So the act, I'm thinking what you're saying is the act was trying to make it so that the default was that the artists would own their work and the publishers would have to step in. But that's not what happened. Instead, the publishers just turned everybody into kind of temps or less than full time, right? They're for hire, so they're in this other ambiguous category where they don't seem to have as many rights. What can... but I feel like you could be clearer about that, and then I wouldn't have had to talk myself through so much. So what can creators do when the law fails to protect their rights? Well, in 1988, a group of successful independent comic creators, including Scott McCloud, blah, 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 all met at a summit to discuss a creator's Bill of Rights. This effort was a direct response to a lot of the creators' personal feelings on how their work was being published, either in the past or at the time, and they spent several meetings deliberating on the wording of a document that would accurately portray their attitudes and beliefs towards this, a manifesto of sorts. I love manifestos. The document, I'm being serious. A document enumerates many rights that the creators demanded, including things like the right to full ownership of that which we create, the right to move freely to and from from publishers, the right to prompt and complete return of our artwork in its original condition. Though the rights illustrated in the Creators' Bill of Rights may not have made an enormous impact on the industry at the time of its drafting. Ooh, you don't need an apostrophe there. That's just, it's drafting. It still provides an interesting window into the attitude of comic creators at the time. Definitely. What window does it show, though? I'm not sure you've picked out a particular thing that was interesting. Many creators today argue the bill's relevancy as it foreshadows future movements in the industry like Image Comics and grows ever more increasingly relevant in the age of superhero movies. The bill is very relevant, says comic artist present at the writing of the bill. I think that everything that has happened since, not just in comics but in many other industries that are driven by the creative arts. Yeah, that's not what you meant. You're missing a word there. I think it's very relevant, perhaps more now in this era of continuing corporate consolidation than ever before. So you don't need that comma there. You can get rid of that because you have that period at the end. I know these punctuation rules are insane. This rings ever true, as shown in the aforementioned case of Kirby versus Marvel Comics, that creators ought to have more protective rights in an era of corporate encroachment. Okay. I think I get what you're saying. Okay, clearly there lies a problem in the creative industry that exists since its inception. Oh, you don't need an apostrophe there either. Just take that baby right out. The fact that a company, so because it's not that has existed since it is inception, right? And then you don't need the apostrophe. The fact that a company can treat those that need most in such a deplorable manner should disgust and revile those with even an ounce of sympathy for individuals working in these industries. The answer is clear. There ought to be a broad and all-encompassing legislation, or at the baseline, some form of protection or unionization. That applies to all creatives. Everyone protects their rights. If not this, then perhaps more specific rights pertaining to particular industries. The fact of the matter is that all creators should be able to retain the rights to their work if they are the sole creators of it. That should be the baseline right that all creators should be entitled to. Cool. And then your works cited, which you've always been great with, so I'm looking at it and it looks like it's also great this time. Okay, so again, looking back at your whole piece, I feel like the component that is missing is you admitting, not like admitting, but you conceding that the publishers have a possible place in the industry, but they have had too much control over intellectual property in the past, and kind of define, even just a little bit, like how much they should have versus how much an artist should have. Because I feel like mostly in the paper, you're just taking the position that artists should own all of their creative rights over everything they do forever. And I mean, it seems like the most artist-friendly version of this is that at least the publisher has rights. I mean, they have rights to publish it that one time, right? Maybe not for future times, maybe not forever, but finding that reasonable spot between the needs of the publisher or the network to like continue to exist as a way for artists to get their work out versus the rights of the creator. So I hope that was helpful, and you got all those cat sounds, no extra charge. Hey.